This is in the matter of the people of the state of Michigan versus Christina Marie Morgan. We have file number 23-21246 FH, 22-21167 FH, 22-20937 FH, 22-20938 FH, and 22-20939 FH. File number 23-21246 FH is set for arraignment today, but the others are set for pretrial at the same time. So, Ms. Van Duzen, does your client waive the reading of the felony information on the arraignment box?
Yes, Your Honor.
Right. And have you received a copy of the felony information and witness list and request for discovery?
I have, Your Honor.
Okay. With regard to that file, are you asking the court to enter a plea of not guilty, or
We're going to
stand
plead
you?
today, Your Honor, on all files.
Okay. So I'm going to start out with one file and ask you what's going to happen on that file, and then work my way down the list. Is that all right?
Yep.
Because there's so many. On file number 22-20937 FH, what will she be doing on that file?
That one will be dismissed, Your Honor.
Okay. And all right. And then let me know which count she's pleading to on some of these files. So on file number 22-20938 FH, what will she be doing on that file?
The whole file will be dismissed.
Okay. 22-20939 FH.
That one she will be pleading guilty to.
Right, which counts?
It would be the embezzlement, Your Honor, or retail fraud 5-year.
Okay, let me pull the file and figure out which counts.
Okay. I think that's the only count in that one.
These are being dismissed. 39. Right, on that file, there are 4 counts of check no account.
Just
On file number 20939 FH, I show count 1 through 4 are check no account with a third offense habitual offender.
gonna just.
If I could butt in here,
Oh,
Ms. Van Dusen, I think the plea was to file ending 3-7.
Mm,
And all the other cases would be dismissed.
Let me go back. Number. All right, on that file, it's a retail fraud first degree, Mr. Sneed.
Correct. I'm just looking at Phoebe's notes here.
that is correct.
Okay, so. And then all the other files would be Nolle trust.
That's correct.
Right, Judge.
And Your Honor, Ms. Morgan is going to try to get into sobriety court, or not sobriety court, drug court. I tried to get a hold of Sarah Teskey, Ms. Teskey, but I gave her the wrong information, so I have to give her her phone number.
Okay, so, all right, so in that file, she's gonna feed straight up to count 1 with no habitual, is that correct?
Yes.
That's correct.
Okay, and then you're asking for it to be screened for drug court, okay. So, Miss Morgan, you wanna raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, this is Madison Township. Does Madison Township do their own fingerprints? Do you guys know? Mr. Sneeder, Miss Van Dusen?
No, they don't. So they do them at the Illinois County Jail.
All right, so Miss Morgan, I show that I don't have fingerprints on this file. So I'm going to need you, we'll send out an order, but you're gonna need to go to the jail and get fingerprinted, all right?
Okay.
All right. All right, so. hold on, my stuff is all reversed, I don't know what happened.
Oh, shoot,
Huh?
I made a copy of your scripts. Did I reverse them?
Yep, that's okay, I fixed it.
Okay.
All right, so, did I swear?
What's
I
that?
swore in. All right, so can you state your name for the record, please?
Christina Marie Morgan.
All right, Ms. Morgan, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty on file number 22-20937FH to count 1 retail fraud first degree?
Yes.
All right, do you understand the maximum penalty for that offense could be up to 5 years in prison and or a $10,000 fine or 3 times the value difference in property, in price of property stolen, obtained, or attempted to be obtained, whichever is greater, and you may be required to pay state and local government reimbursement for this offense. Do you understand that?
Yes.
Are you satisfied with Ms. Van Dusen as your attorney and the advice that she's given you?
Yes.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
That's correct.
And Ms. Van Dusen?
That's correct.
And Ms. Morgan, is that correct as far as you're aware?
Yes.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yeah.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that are given to you?
No.
All right. How do you wish to plead to the charge that on or about the period of March 8 of 2022 through March 25 of 2022 in Madison Township, in the county of Laraway, that you did commit the offense of retail fraud first degree? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Ms. Van Dusen?
No, Your Honor.
All right, Ms. Morgan, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty? Is it your own choice to plead guilty?
Yes.
Okay, so Ms. Morgan, between the time period of March 8 of 22 through March 25th of 2022, did you enter Walmart?
Yes.
Okay, and would you agree Walmart is in Madison Township in the county of Laraway?
Yes.
And at that time, did you take property from Walmart that had a value of $1,000 or more?
Yes.
Okay, and when you took that property, your intention was to deprive Walmart Corporation of the value of that property, is that correct?
Yes.
Okay, do you remember what you took?
Not right offhand. I would have to think about it. Those little things. That's why when you answered about the $1,000, I had to stop and think, but yeah.
Okay, Mr. Steen?
People are satisfied, Judge.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Steen?
Yes.
Ms. Van Duzen?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights, and she does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. And Mr. Moore, could you also put a note in there to have her screened for drug court?
Yes, and I guess I didn't hear, but it looks like restitution applies in all the dismissed cases.
Okay.
That, if I could address that, that is part of the plea bargain. And in addition, I spoke with Ms. Van Duzen. And file ending 6-7 FH is also going to be plea as charged with no subs.
Oh,
So 2 out of the 5 cases are pleas and 3 are being dismissed.
Okay, so I gotta add file number 21167.
Yes.
Yes,
please,
Your Honor,
Judge.
sorry.
Okay, all right. So Ms. Morgan, all right, so on file number 22-21167 FH, she's gonna plead to count 1.
That's correct, Your Honor. There should
Alright.
only be 1 count in there.
There
right?
is.
Okay. Sorry, Your Honor.
So, Ms. Morgan, it looks like the plea agreement also involved you pleading to an embezzlement on file number 22-21167 FH. Is that your understanding?
Yes.
Okay, so I've already gone through your trial rights. Do you need me to go through them with you again?
No.
Okay, now on that file, conspiracy to commit embezzlement, count 1, agent or trustee 1,000 or more, but less than $20,000, does carry a maximum penalty of up to 5 years in prison and or a $10,000 fine, or up to 3 times the amount embezzled, whichever is greater. Ma'am, is it your intention then to plead guilty to this charge as well?
No.
No?
No.
Yes? I'm sorry, can you say that again?
Then no.
You're not
Is it your
pleading to it,
intention-
Ms. Morgan?
Is it your intention to plead? I'm sorry, it's just muffled, I'm sorry. Is it your intention to plead guilty to this count?
Oh, yes. I'm sorry.
No, it's okay, it's okay. All right, so ma'am, on August 26th of 2022, were you in the village of Clinton in the county of Laraway?
Yes.
At a Shell gas station?
Yeah.
Okay, were you employed by Shell gas station?
Oh, Shell. No, I was not employed by Shell. I'm sorry. It was muffled.
So my felony information says Shell gas station.
I was not employed there.
Also known as Johnny's.
Where did you work? Did you work at somewhere in Clinton at a gas station?
No. I've only worked at 7-Eleven and Taco Bell.
Richard Guru.
Darrow?
Correct?
It's a conspiracy, Judge.
Okay, so did you know a Richard Garrow?
Yes,
Okay, did he work there?
he did work there.
Okay, so, and you knew him.
Yes.
So did you make an agreement with him and conspire with him to take merchandise like lottery tickets, money, and other merchandise from that store?
No.
All right, so I need a little help here. So either Ms. Van Duzen or Mr. Sneed.
Yes. Were you dating Mr. Guru or was he a friend of yours?
We were dating.
Okay, and is it true that you went into the store and purchased items?
I used my food card. I didn't actually give him cash. I don't,
But did you know that he was not ringing up part of your merchandise?
no, I did not know that at the time.
Okay, then we're gonna have to retract all
Alright.
of them then. Or let me have a
Alright.
talk with her real quick. Yana, can I have a breakout room with her real quick?
Sure. All right, so I'm gonna open a breakout room. And then otherwise I'll just set it for another day. All right. To sign. All right, go ahead and join that breakout room. Mr. Dagger Margosian, it looks like most of your clients, do you have anybody that's not in jail? I don't think so.
No, Your Honor. Good morning. I just have Mr. Overton and Mr. Deck. And they're both in
So
jail.
I have Dawn's jail lined up first, so I don't know if you want us, just wait, and I'll get Miss Overton next.
That's fine. I mean, I have one thing over in Judge Olsaver's court. I don't know when that would get called. So is there just
Want
one?
to scoot over there and see if you can get that one called and come back?
That's fine. I'll just come back then.
Mr. Murphy, who do you, Miss Van Duzen, you're back?
Yes,
And
we
so
can
is
finish
Miss.
this for you, Your Honor.
Okay, so, do you want to voir dire her then, Miss Van Duzen?
Yes. Miss Morgan, is it true that you were at the store and with Mr. Guru? Could she hear me?
I
Yeah.
think there's a delay.
Yeah. And he is your boyfriend, correct?
Yes.
Okay, and you were going to purchase some items and you placed them on the counter, is that correct?
Yeah.
And you knew that he did not ring up quite a few items, is that correct?
Yeah.
And so you conspired with him to embezzle those products, is that correct?
Yes.
Okay, no further questions.
All right, Mr. Sneed, are you satisfied with the factual basis of that plea?
Yeah, if we can stipulate those items amounted to $1,000 or more in value.
Ms. Morgan, would you agree that the value of the property taken from with Mr. Girl at the Shell gas station were $1,000 or more?
Yes.
And he was employed there, right?
Yeah.
All right.
People said trouble.
All right, is there any other restitution she needs to make an admission on, Mr. Sneed? On the Nolle cross files?
If I could have one moment.
Yeah, no, we can stipulate that if there is any restitution on the other files, that she is liable for it.
All right.
Yeah.
Okay. All right, has the court complied with MCR 6.302 B, C, and D? Mr. Steen,
Yes, Your Honor.
Ms. Van Duzen?
Yes, Your Honor.
All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have, or she does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I will, Ms. Van Dusen, are you available April 7th at 8:15?
Yes, Your Honor.
All right, I will set this matter for sentencing on April 7th at 8:15. And Ms. Morgan, that'll be in person. So I'm gonna need you to come to the courthouse that day, all right? All right, and then I'm going to refer you for screening for the drug court. So I'm gonna need you to follow through on all the instructions for that. Now I'm gonna put you in a breakout room with Tom Moore from the Michigan Department of Corrections. He's gonna give you some instructions. One, when you meet with the probation department, you will need to be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. It'll be provided to Ms. Van Dusen before sentencing. And we will see back on April 7th at 8:15. Now, Sarah Teskey from the drug court program will contact you. So make sure you return a call and communicate with her, or whoever calls you from CMH. It might be someone else from CMH, but they'll screen you for drug court, okay?
Your Honor.
Yes, ma'am.
I recently I've been with Darren Cost, and I have been doing color green.
Yep,
I just wanted to.
yep, yep, and that's good. Darren Coast is pretrial services, so you'll continue with him until sentencing, but you still need to meet with the probation department, all right?
Okay.
Okay, so Ms. Morgan, I'm gonna put you in a breakout room with Mr. Moore. When you're done talking to him, go ahead and disconnect, all right?
Okay.
Thank you.
Thank you.
All right, I have a gentleman from the jail. Can I ask your name, please?
Richard Kelly.
All right, Mr. Kelly, let me find you. Hold on, I'm trying to find you. Okay. This is in the matter of the people of the state of Michigan versus Richard Eric Kelly. We have 3 files. We have 23-21210 FH, 23-21211 FH, and 23-21212 FH. I have Isaac Sneed appearing on behalf of the people, and I have Dawn Van Dusen appearing on behalf of Mr. Kelly. This is the date and time set for a pretrial in this matter. Ms. Van Dusen, how would you like to proceed today?
Your Honor, I need a breakout room with Mr. Kelly really quick.
All right, so I'm gonna open up a breakout room and assign you Mr. Kelly. You'll either go automatically or you'll have to use the mouse and click on join. Thank you. All right, so Mr. Murphy, do you represent Matthew Martin?
Good morning, Your Honor. I have Dennis Herman.
Oh, he's here. Let me grab his. You let him in. His file. Were you subpoenaed to be here today?
I had a notice, yes.
So, Mr. Sneed, did you subpoena anybody from law enforcement for Mr. Dietos?
No, typically not for pre-trials. There's no subpoenas. I think the agency gets a courtesy copy of the notice of the hearing, which does say notice to appear on it, but law enforcement's not required to appear.
You can go.
If it's okay with you, stick around for the hearing.
It could be 2 hours.
2 hours.
So I have about 40 people and it's Zoom. So I don't know when, and that attorney is gonna be in Judge Olsaver's until he comes to mine. So you're more than welcome to hang out. But it could be an hour, it could be I have no idea when his attorney will get down here, so I'm sorry.
That's okay. No, I appreciate your consideration. Thank you.
It's, all right, this is in the matter of the people of the state of Michigan versus Dennis Allen Herman. We have file number 21-20576FH. Let me get to his file in here. Hold on. I have my paperwork. This is, all right, so we have Jackie Weiss appearing on behalf of the people. Oh, I thought we did. We have Isaac Sneed appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Herman. This is, in fact, one of my older files. So today we'll either need to plea or set a trial date, unless I already did. Let me see. Did I already set a trial date? No, but I have a second
in regards to Mr.
amended
Herman,
information.
we had a trial set and then there was, I guess quite frankly, I think there was an issue about restitution. At this time, from my understanding, the plea offer that Mr. Herman wanted to accept would be for him to do a no contest plea to a destruction of property misdemeanor, 200 to 1,000. Restitution would be determined at a hearing. So Mr. Herman wanted, if that was still the case, Mr. Herman wanted to again accept that offer and do a no contest today, and then schedule a restitution hearing for a later date.
Mr. Sneed, is that plea still available?
Yeah, I just want to make one correction. We submitted a third amended information that has count to being malicious destruction of property less than 200.
Sorry.
Oh. So I don't have that third amended information, but it's MDOP less than 200, so a 93 day.
Correct. I'll email that over right now.
Okay, it's even better for you, Mr. Herman. All right, so Mr. Murphy, then, is your client willing to accept that plea?
From my understanding, yes, is that correct, Mr. Herman? You wanted to do that today? No contest to the misdemeanor?
As long as there's a restitution hearing.
Yeah, you have a right to a restitution hearing. So what will happen is pre-sentence report will list what they believe restitution to be. And then Mr. Murphy will discuss that with you. And if you don't agree, you can request a restitution hearing. You have that
John,
right.
I know at this time we're going to request a hearing. I know it's already going to be an issue, so I'd rather just get that done right now and schedule that hearing right now if possible.
Okay, all right, Ms. Adams, an hour?
Okay.
Mr. Murphy?
Probably, Mr. Sneed, that seem right?
Yeah, tops.
Okay, all right, so I'm gonna ring them while Ms. Adams looking for an hour. Mr.
we're
Herman,
looking-
want to,
I'm sorry, are we looking before sentencing? Is that what you're saying?
yes,
Go ahead, I'm sorry.
no, it's okay. All right, so Mr. Herman, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so Mr. Herman, you've heard the statement of your attorney. Is it your intention to plead guilty to an added count, let me see,
No
count
contest, Your
two,
Honor.
or I'm sorry, to plead no contest to count two, malicious destruction of personal property less than $200, which carries a maximum penalty of up to 93 days in jail with a right to a restitution hearing. Is it your intention to plead no contest to that count?
Yes, ma'am.
All right. Are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, ma'am.
Neither the prosecutor nor the defendant nor anyone on the defendant's behalf has discussed any possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Murphy
Yes, Your Honor.
and Mr. Herman, is that correct as far as you're aware?
Yes.
If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Herman?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand that?
Yes, ma'am.
I think they changed it because the other one wasn't added count for a plea. Right, so I think originally this count 2 was added just for purposes of the plea. I think it was a plea offer. So Mr. Sneed, the second amended information had a count of larceny less than 200 as count 2.
Yeah, that was an error, I believe. So it should be the third amended, and I did just email that to Becky.
Okay,
So, count 3.
we'll let the clerks and the prosecutor figure that out. Okay, all right, thank you.
Sorry about that.
It's a coding thing and it's way above my pay grade and I don't understand it, but we'll figure it out later. All right,
Okay.
so Mr. Herman, do you have any questions about the rights that I've given to you?
No, ma'am.
All right, and this is a no contest plea. So Mr. Herman, how do you wish to plead to the charge that on or about August 8th of 2021 in Medina Township in the county of Laraway, that you did commit the offense of malicious destruction of personal property less than $200?
No contest?
Yep. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Sneed?
No, Your Honor.
Mr. Murphy?
No, Your Honor.
All right, so Mr. Herman, other than what was placed on the record, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, ma'am.
Is it your own choice to plead no contest?
Yes, ma'am.
All right, who will be placing the factual basis on the record?
I can do that if Mr. Steen has no objection.
No objection.
So, Your Honor, we would stipulate to the following facts as they would prove that on or about August 8th of 2021 in Medina Township, the county of Laraway, state of Michigan, that Mr. Herman did have an interaction with a Joy Herman's vehicle, that he did throw I guess it would be a plow, that was being used as a lawn ornament. It was a metal plow. That plow did strike the vehicle, causing an amount of damage to that vehicle. Obviously, the amount of damage to that vehicle and the amount of restitution is yet to be determined. But Mr. Herman would accept, or that I believe the evidence would establish again that Mr. Herman did throw that object and it did cause damage to that vehicle. I believe that would establish the factual basis.
Okay, all right. Mr. Steen?
I think we just stipulated did cause some monetary damage, and that amount is to be determined.
Yes, we would stipulate that there was some monetary damage to that vehicle. Just the actual amount yet to be determined at a restitution hearing.
Okay, all right. Well, based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that the defendant did on August 8th of 2021 in Medina Township in the county of Laraway throw a plow at a vehicle causing destruction or injury, which the value is yet to be determined, but for purposes of the plea, would be somewhere under 200 or over 200 because we need a determination on that. All right. And therefore did commit the act of malicious destruction of personal property less than $200. Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, it had one.
And Mr. Murphy?
Yes, Your Honor.
All right, I accept the plea. As I said, it's been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting on the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Herman, in a few minutes, I'm going to put you in a breakout room with Mr. Moore from MDOC so he can get you, or wait, this is a misdemeanor. So actually, Mr. Herman, I'm going to require you to report Thursday morning, tomorrow morning, between 8 and 10 in the district court probation office, and just check in, tell them your name, and they'll have the file, and they'll give you instructions on how to follow up to do a pre-sentence report. Ms. Adams, what would be the date available for a restitution hearing?
So Judge, I'm looking at February 22nd at 1:30. We do have a jury trial scheduled that day.
Who's the trial attorney?
Sam, Mr. Malero.
Who's the defendant?
Christina Edmonds.
That's not going.
Well, you're not supposed to know that before I do. Okay, so, all right, so Mr. Murphy and Mr. Sneed, February 27th at 1:30.
Yes.
Let me just
Becky,
double
you
check,
said-
Your Honor.
Becky, you said February 27th, right?
22nd, 2/2.
Okay,
That should work
I'm
for the
sorry.
defense, Your Honor.
February 22nd, I'm sorry, misspoke, Mr. Sneed.
That works, Judge. Thank you.
All right, so we'll set that for restitution, February 22nd at 1:30. Will that be in person or Zoom?
I have no preference, Judge.
I'll be there in person. I think I don't really care though if Mr. Herman appears in person or not, or if Mr. Sneed appears in
Mr.
person.
Herman, do you want to be in person or via Zoom?
I have to be at work at 2, but I can take some time off.
Okay, so if you work at 2 o'clock, Miss Adams, when is the next available time in the morning, like at 11 o'clock? Or, 10 o'clock or something.
On March 2nd, you have the criminal justice meeting. I don't know if you want to put it in there.
That's at 10.
Yes,
What do I have at 11?
nothing.
So March 2nd at 11?
Yep.
Mr. Murphy, Mr.
That'll be
Sneed?
fine for myself. Is that okay with you, Mr. Herman?
Yes,
Good for the people.
All right, so we'll put that at March 2nd at 11. And again, I would ask, Mr. Herman, do you want to come in person or do you want to be via Zoom?
I can be there in person.
Okay, so we'll put that in person. All right, and I will schedule sentencing for April 7th at 8:15 in the morning. And do you want that to be in person or via Zoom, Mr. Murphy?
I guess at this point, I'll talk to Mr. Herman about that. I usually just do them through Zoom. That's what my preference would be unless Mr. Herman wanted me to ask for something different.
So Mr. Herman, do you want to appear for sentencing like you are today, or do you want to be in person? You have a right to be in person.
Zoom's fine.
All right, we'll set that via Zoom. All right, so, so as I said, Mr. Herman, report to the district court probation department tomorrow morning between 8 and 10. Be truthful with them about your background. We'll see you back here on March 2nd at 11 for a restitution hearing and April 7th at 8:15 via Zoom for sentencing. All right, anything else? Mr. Murphy?
Nothing further from the defense, Your Honor. Thank you.
All right, thank you.
Mr. Herman, just contact my office after you talk to probation tomorrow and make an appointment, okay?
All right, thank you.
Thank you, Your Honor. You have a good morning.
You too. Thank you. All right, Ms. Van Duzen, we're back with Mr. Kelly. So how do you want to proceed today with Mr. Kelly?
Mr. Kelly's going to plead not guilty on all files, and we're going to ask for a pretrial date within the next couple weeks, and a jury trial.
Okay, so it looks like this is a first pretrial. So, my next available pretrial is March 15th.
That works, Your Honor.
Okay, so we'll set these matter for pretrial on March 15th at 8:30 in the morning. And you're looking for a trial date as well?
Yes, Your Honor.
I'm sorry, Mr. Kelly, did you say something?
Unless you said we could do this next week. I'm losing out on work by the hour.
I don't know, Ms. Adams, do we have, well, next week is the 22nd. Is that enough time for you, Ms. Van Duzen?
It would be, yes, Your Honor.
Okay, I can do next week at least. All right. Do you want me just to do a pretrial at this time, and next week we need to set a trial date? We will.
Yes, Your Honor.
Okay, so I'll set this next week, February 22nd, 2023 at 8:30 in the morning for a pretrial. And let's see, you can do the stip in order to adjourn.
Yes, Your Honor.
Yeah, if I may, can I ask, what is my total on my bond right now? I don't know what it is.
Let's see. Looks like you have a PR bond on file number 23-21210 FH. You have looks like you have a 10,000 cash surety bond on file number 23-21211 FH. And on file number 23-21212 FH, you have a 5,000 cash surety bond.
Okay, I appreciate it.
Yep, we'll see you back here next Wednesday at 8:30 in the morning. Thank you, Ms. Van Duzen.
Thank you.
All right, so from the jail, if I could get do you have anybody else? Oh, I don't think you have anybody else in jail, Ms. Van Duzen.
No, I don't.
Okay, so.
Yep.
All right, so Matthew Martin. Laraway, Lisa Hannawalt.
Judge, do you want me to see if they can get Mr. Signs from the jail?
Are you doing pickups? Is Rhonda Underwood gone this week, Ms. Van Dusen?
I'm not doing the pickups, Your Honor. I don't know who's doing
No,
them.
I don't want him.
Okay.
Actually, Mr. Degermer just logged in. If I could get Shannon Overton.
Okay.
Mr. Bice, you represent Mr. Bice.
Yes, Your Honor, I do.
I'm trying to go through the waiting room and find the people that you represent. There. No, all right, Mr. Bice, can you hear me? Nope. Mr. Bice, can you hear me now?
Yes, I can. Sorry about that.
Not a problem. All right, this is in the matter of the people of the state of Michigan versus Tyler James Bice. This is file number 22-20975 FH. I have Dawn Van Dusen appearing on behalf of Mr. Bice, and I have Isaac Sneed appearing on behalf of the people. Ms. Van Dusen, how would you like to proceed today?
At this time, Mr. Bice is going to plead not guilty. We're going to ask for another pretrial. He went through Dawn Farms, and so it's a matter of being able to talk to the prosecutor at this point because he has transitioned out and doing very well. So we just need one more pretrial to see what the offer will be now.
So, Mr. Bice, you're at home on New Vision now, right?
I completed, yeah. So I got transferred from Dawn Farm to Home Division and completed that, and then stayed in a transitional home, and now I'm out of that, living up here with my dad, going and working and going to meetings.
Okay. All right. So Ms. Van Dusen, would March 15th be okay?
Yeah.
Okay. So we will set this for another pretrial on March 15 at 8:30 via Zoom. And Ms. Van Dusen, can you do the step in order to adjourn?
Yes, I will.
All right. All right. So keep up the good work, Mr. Bice, and we will see you back on March 15th at 8:30.
Okay, thank you.
Thank you.
Bye.
Bye-bye. All right, do you represent Joe Johnson?
Yes, Your Honor, I do.
All right. Miss Overton?
Yes, ma'am.
We're just waiting for Mr. Dagger Margosian to connect. And Mr. Johnson. All right, Mr. Dagger Margosian, do you need a breakout room with Miss Overton?
Please, Your Honor.
All right. So Miss Overton, I'm going to change your screen name just in case I get another Zoom connection.
Oh, there. Sorry about that.
All right, hold on, Mr. Jensen.
Yep.
All right, I'm going to assign Miss Overton and Mr. Dagger Margosian to a breakout room. Go ahead and click on join that breakout. All right, this is in the matter of the people of the state of Michigan versus Joseph Anthony Johnson. File number 22-21089 FH. And this is date and time set for a pre-trial, I believe, in this matter. So, Ms. Van Duzen, how do you wish to proceed today with Mr. Johnson?
Mr. Johnson's going to plead not guilty, Your Honor. We need to set this matter for a trial. And I asked Mr. Johnson to get an appointment with my office as soon as available so we can prepare for trial.
All right, so just for my notes, has a plea offer been made?
Yes, Judge. The people offered to reduce count 1 to a misdemeanor, attempted resisting and obstructing, have the defendant plead guilty to count 3, reckless driving. So basically 2 misdemeanors, and the remainder would be dismissed.
That is correct.
Okay. Got it. Okay. So, Ms. Adams, that's about a 1-day trial. Would you agree, Ms. Van Duzen?
Correct.
All right, so Ms. Adams, I'm looking for a 1-day jury trial.
Got a week jury trial and then another backup March 7th. I don't know if you want it on here.
What's the week one?
Marcus Monroe.
And is there anything scheduled, like, I don't know, go the next week, maybe?
And then you've got 3 scheduled March 14th.
Who are the attorneys on those?
Wad, Murphy, and I'm not sure on the other one.
Do you want to back up to that, Ms. Van Duzen?
Yes, Your Honor.
All right, what was that date, Ms. Adams?
Tuesday, March 14th.
All right, so we will set this for a trial date of March 14 of 23. That'll be at 9 a.m. for 1-day jury trial. I will require that all motions be filed and heard, jury instructions specific to this case and voir dire case questions specific to this case be provided to the court by March 10. And plea deadline. So is there anything else with regard to this file?
No, Your Honor.
All right, so Mr. Johnson, you're set for jury trial on March 14th of 2023 at 9 a.m. If Ms. Van Duzen, you and Mr. Johnson, he decides that he wishes to take a plea, I would much prefer we do it before the day of trial, because it's not, jurors come in, like I had a full panel the other day. It's just easier if I can call off the panel than make him come in. So, so Mr. Johnson, plea offers to 2 93-day misdemeanors. That would be a term of probation. I can't see that there would be any upfront jail, and then you'd be on probation for me with like a year. So that's the plea offer made right now. So we'll see you back here on March 14th at 9 a.m. for jury trial, unless we're back soon. I've done the scheduling order.
Okay, thank you, Your Honor.
Thank you. And that'll be in person, Mr. Jensen. So you got to be here in person.
Okay, thank you.
All right.
Have a good day.
You too. Are you just watching, or are you a defendant, or you have court? Yeah. What's your name? Okay. Ms. Van Duzen, I have Ms. Wilt in the court. We want to come up to the podium. All right, this is in the matter of the people of the state of Michigan versus Macy Alexandra Wilt, file number 22-211 40FH. This is a date and time set for a pretrial in this matter. So Ms. Van Duzen represents Ms. Wilt and Mr. Steen on behalf of the people. So Ms. Van Duzen, how do you wish to proceed with Ms. Wilt today?
Unfortunately, Your Honor, I need to have a brief discussion with Ms. Wilt. Her phone number was not working.
All right, so in the hallway, there's a device against the wall. So go out the door to the left and there's like an iPad, log into Zoom, and I'll be able to put you in a breakout room with her, okay? You're welcome. All right, this gentleman is not connecting. So. All right, I have a gentleman on a Samsung device. What is your name, please?
Rodney Hill.
All right, good morning, Mr. Hill. And who's your attorney, Mr. Hill?
Sam Malaro.
All right, so Mr. Malaro is in front of Judge Olsaver. So I'm gonna put you in the waiting room and then when he gets here, I'll bring you back in, all right?
Okay. Okay.
All right, thank you, Mr. Hill. So it's hallway connected. All right, there you go. So Ms. Wilt, I am going to put you in a breakout room with Ms. Van Duzen. When you're done, just go ahead and disconnect the device and come back in the courtroom, all right? Okay. All right, so. All right, I've opened that breakout room. Go ahead and adjourn it. All right, Mr. Dagger-Margosian, you represent Ms. Overton. So this is in the matter of the people of the state of Michigan versus Shannon Lee Overton, file number 23-21245FH. I have Michael Dagger-Margosian, well, I have Isaac Sneed appearing on behalf of the people, and Michael Dagger-Margosian appearing on behalf of Ms. Overton. This is the date and time set for arraignment. Court has received the felony information. Mr. Dagger-Margosian, you waive the reading of the felony information.
I do, Your Honor.
All right, have you received a copy of the felony information prosecutor's request for discovery and witness list?
Yes, Judge. Yeah.
All right, how do you wish to proceed today?
Stand mute, Your Honor. And I also just wanted to say that Mr. Sneed and I have a proposed resolution in place, but before we enter that, I would like Ms. Overton to be screened for drug court, and or maybe we could set up a time to have a Cobb's discussion with Your Honor.
Okay, so all right, so you'll send the notice to have her screened for sobriety or for drug court, and then you can just call Miss Adams whenever you're ready, and she'll set up a Cobb's just a meeting if you'd like, or bench conference.
Will do. Thank you.
Could I, Your Honor, could I interrupt? Sorry. My understanding is that Ms. Overton's a resident of Jackson County, not Nolle County. And if that is the case, she would not be eligible for drug court here.
That's true. She wouldn't be eligible here, but there is a drug court in Jackson. She'll be able to.
Okay, thanks.
Thank you, Mr. Steve. So I have her as Saginaw, Michigan. So where do you live, Miss Overton? What county, what city?
It's Jackson, Michigan, Your Honor.
Okay,
Saginaw was the residential house that I was living in.
okay, you know, we could probably screen her, but it would be for purposes of transfer to the one in Jackson, I think. Okay, so Mr. Dagger-Margosian, I'm going to enter a plea of not guilty on behalf of Miss Overton. And we will set this for another pre-trial about April 5th at 8:30 in the morning.
Is there anything, I mean, if that's all we have, that's all we have, but if there's something.
That's all I have available, but if you guys resolve it, you can bring her in anytime. Just bring her in any day other than a Wednesday, all right?
Very good, thank you, Honor.
So Miss Overton, April 5th is like a month away, but understand that you can be brought in sooner if you decide to enter a plea, okay?
Okay, thank you, Your Honor.
And my office will do that notice because it was an arraignment, all right? Thank you.
Okay,
Ms.
thank
Overton.
you.
Matthew Martin, Lisa Hannawalt, Mr. Hill, any of those yours, Michael? No, just Jesse Duck.
Yeah.
Try to get them next from the jail. So Becky, can you let the jail know I like Mr. Duck, or Jesse Duck next?
Okay.
All right. All right, you want to come on up to the podium? All right. So I've got Miss Wilt back. All right, so Miss Underwood, in the matter of the people of the state of Michigan versus Macy Alexandra Wilt, how do you wish to proceed with Miss Wilt?
She's going to plead guilty, Your Honor, and I'm Miss Van Dusen, not Miss Underwood. But she's going to plead guilty to attempted R&O. It'll be an added count with no objection to HIDA.
Is that correct, Mr. Steen?
We'll accept that plea, Your Honor. Thank you.
Okay. All right, so count 2, attempted R&O, no objection to HIDA. All right, so Ms. Wilt, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Yes, Your Honor. Now, you have heard the statement, or state your full name correctly. Macy Alexandra Wilt. All right, now you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2, attempted resisting or obstructing a police officer? It's receiving concealing. Oh, I'm sorry. Attempted receiving concealing. Yes. Which is what misdemeanor, 93 day? Or 1 year?
Your Honor, the people would accept a plea to receiving and concealing 200 to 1,000, which I believe is a 1 year.
Yeah, that's correct.
Okay. So 1 year, no objection. All right, thank you. So is it your intention to plead guilty then to count 2, attempted receiving and concealing, which carries a maximum penalty of up to 1 year in jail? Yes. Okay. Are you satisfied with Ms. Van Dusen as your attorney and the advice that she's given you? Yes. Right. And neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than if she qualifies, she would be sentenced under the Homes Youthful Training Act. Is that correct, Mr. Steen?
Yes, it is, Your Honor.
Ms. Van Dusen?
Yes, Your Honor.
Ms. Wilt, is that correct as far as you're aware? Yes. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, You may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. You understand that? Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that? Do you have any questions about the rights that I've given to you? No. All right. And do you understand if you're not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization? Okay, so Miss, how do you wish to plead to the charge that on or about September 29th of 2022 in Palmyra Township in the county of Laraway, that you did commit the offense of attempted receiving and concealing stolen property?
Guilty.
Guilty. Is that 200 to 1,000, right, Mr. Sneed?
Yes, it is, Your Honor.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge? No. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to end the plea? Yes. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Steen?
No, Your Honor.
Ms. Van Duzen?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimate of what your sentence will be? No. Do you and it's your own choice to plead guilty? Yes. All right. So Ms. Wilt, on September 29th of 2022, are you in Palmyra Township in the county of Laraway? Yes. All right. And at that time, did you receive some stolen property? Buy, receive, possess, conceal, or aid in the concealment of some hayride, bail, elevator, checks, financial documents, jewelry. So did you get some property from somebody? Yes. What'd you get?
It was a hay elevator. It was outside my house. And yeah.
Anything else? Some jewelry, some money, checks?
I believe that there was checks found. I don't know if there was jewelry, but.
So who brought those to your house?
It was done while I was not there. So I'm not exactly sure.
So all this property just showed up at your house, you have no idea how it got there?
I'm not the only person that lived there.
So how did it get there?
I'm assuming somebody that was in or out of the house.
Okay, and you didn't offer to help them?
No.
So, Miss Van Duzen is gone. Where did Miss Van Duzen go? Okay. I lost Miss Van Duzen, and Miss Wilt, have a seat, all right? Yeah, just sit over there, that's fine. I'll put your file to the side because I don't know what happened to Miss Van Duzen. All right, so who do I have at the jail?
Jesse Dack.
All right, Mr. Dack, I'm going to change your screening. And Ziggers, Mr. Decker Margosian, right?
Yes, Your Honor.
All right, so these files are in the matter of the people of the state of Michigan versus Jesse Anthony Deck. We have file number 23-21251 FH. 23-21252 FH and 23-21253 FH. I have Isaac Sneed appearing on behalf of the people. I have Michael Dagger Margosian appearing on behalf of Mr. Deck. And this is date and time set for arraignment on these files. Mr. Dagger Margosian, do you waive the reading of the felony information?
Your Honor, before we do that, can I just have a breakout room with Mr. Deck?
Sure. And while we're doing that, I'm going to let my staff take a couple minute break.
The one she's waiting on had waived arraignment this morning.
Were you waiting?
Shannon Heatherly? It says waived arraignment, right?
Yeah, it looks like that. So it looks like they waived arraignment, so they won't be coming in today.
Well, thanks.
Sorry, I just
This
noticed
is
that.
very interesting though.
Oh, you can stay.
No, that's all right. I have other things to do. Thank you. I appreciate it.
Yeah, I just noticed that, so.
I appreciate it.
Yeah.
I was gonna, at 10 o'clock, I was gonna go anyway.
All right, well, you can leave a little early.
Thanks.
You're welcome.
All rise.
Thank you.
All right, so I got Miss Van Dusen back. Hi, Miss Van Dusen. So I don't know when I lost you, so, Miss.
So can you hear her?
Can you get out?
She said, can you hear her?
Huh?
She asked if you could hear her.
I don't know how, without hanging up.
Miss Van Dusen, can you hear us?
I can, Your Honor.
Okay, so Miss Wilt, you want to come back up to the podium? So I don't know where I lost you, so I don't know what you heard.
I heard it all except when you went to ask me the question and then it dropped.
Okay, so at this point, I don't know that I can accept the plea. Because she said she doesn't know where it came from and she doesn't know who brought it there and she had no involvement in that.
She knew it was stolen though.
Did you know it was stolen?
No, I was not aware.
She's denying all of that, so why don't I set this for another pretrial so she can sit down and talk to you? So why don't I set this out to like April 12th? And Miss Adams, can I get a notice because Miss Wilt's here? So I'll set this out to April 12th at 8:30 in the morning. And then obviously at that time, if we decide to plea or set for trial, we can.
Okay, thank you, Your Honor.
All right, so Miss Wilt, you need to make an appointment to go meet with Miss Van Dusen, all right? And just contact their April 12th at 8:30 in the morning, I'm sorry, and we'll do the notice. And so make an appointment to meet with Miss Van Dusen, and then we'll see you back here on April 12th at 8:30 in the morning, and have a seat, and my staff will get you notice here, all right? So I have in my waiting room, let's see, wait. Miss Adams, I do not see Mr. Nolle and Mr. Vasquez. That's John.
I sent you a message on that one. They're adjourning in the meantime.
Okay, so in the matter of, that's that one though, it's really old.
So there's also stuff with all favors. So they worked it out.
Okay, so in the matter of the people of the state of Michigan versus Juan Antonio Vasquez, file number 2019-19463-6466FH. Those matters have been adjourned. What was the date again, Miss Adams?
May 10th.
10 at 8:30 in the morning. All right. Okay, so Miss Van Dusen, I think. Oh, you have Antoine Carter. Have you had contact with Mr. Carter?
Yes, talk to Mr. Herman real quick, Your Honor. I'm sorry, Your Honor, I'm on vacation today, and anyways, I'm using up my days, but I'm still working today.
I know how that goes. So Mr. Carter is not here. He's not called in and he's not zoomed in. Have you spoke with him?
No, Your Honor. His phone is not working either.
All right, in the matter of the people of the state of Michigan versus Anton Deontra Carter, file number 22-21182FH. This is the date and time set for a pre-trial in this matter. Let me see, I do have a notice that was mailed out by my office. Let's see, to the, do you know if he was living in Adrian or Detroit?
Detroit, Your Honor.
All right, we mailed it to the Detroit address, not the Adrian address, and he's failed to appear. I'm going to issue a bench warrant for his arrest for failure to appear and set bond in the amount of $50,000 in cash. Okay. Him. So let me double check. If I have anything else. Takaya Makap.
Yep, I have her too.
All right, in the matter of the people of the state of Michigan versus Takaya Makap, file number 22-21047H. This is the date and time set for a pre-trial. I do have a stipend order to adjourn that was provided to the court, setting it for today's date. And she is not present via Zoom or in the courtroom. Have you been able to have contact with her?
No, Your Honor, her phone number does not work either.
All right, well, we will issue a bench warrant for failure to appear. She charged with, yes, I'll set bond in the amount of $15,000 cash. All right. That one, double check. Have anything else?
Schoonover, Jonathan?
Say it again.
Jonathan Schoonover?
I do not have Schoonover today.
Okay.
And I believe Ms. Van Duzen, those are the only things I had with you.
Okay, thank you, Your Honor.
All right, thank you, Ms. Van Duzen. You have a good day too. All right, Mr. Dagger Margosian, close that breakout room and bring Mr. Deck back, and we can just zoom through yours. All right, so Mr. Dagger Margosian, you had requested a breakout room. I did place you in a breakout room with your client. How do you wish to proceed? Do you waive the reading of the felony information?
Your Honor, we do. We actually have a resolution in this matter, so we can, I mean, if you want, we can go through the formality of the arraignment, but we're anticipating entering the plea, and then at the end of that, I'll be addressing bond with the court.
Okay, so he does waive the reading of the information though. Okay, so starting with, well, are any files being nully processed as part of this plea?
Yes.
Yes.
Which ones?
Your Honor, the plea bargain is that the defendant is going to plead guilty to count 1 in file ending 5-3 FH. And the remaining count 2 will be dismissed. In addition, files ending 5-1 and 5-2 FH will also be dismissed.
All right. Does he admit anything for sentencing purposes on those other files or no?
No, Judge. Thank you.
Okay, is that correct? Recitation of the plea, Mr. Dagger Margosian?
It does. I'm not sure if there's one other file, but it's a misdemeanor, so it's really not in this court's jurisdiction, but my understanding is that case will be dismissed as well, but I'll handle that in district court.
Is that to be dismissed as part of the plea as well, Mr. Sneed?
I don't have note of that. I don't know which file is pending down there.
230187 OT, which was part of this data.
Okay. Okay. Thank you.
Okay. All right, so he's going to plead guilty to count 1, police officer fleeing 3rd degree on file number 23-21253 FH.
Correct.
All right, so Mr. Deck, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth and the whole truth and nothing but the truth?
Yes, ma'am.
All right, can you state your full name for the record?
Jesse Anthony Deck,
All right, so Mr. Deck, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty on file number 23-21253FH to count 1, police officer fleeing 3rd degree, which carries a maximum penalty of up to 5 years in prison and or a $5,000 fine? There will be a suspension of your driver's license. So is it your intention to plead guilty to that count?
Yes, ma'am.
Are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Steen?
Yes, Your Honor.
Is that correct, Mr. Dagger Margosian?
Yes, Your Honor.
And Mr. Deck, is that correct as far as you're aware?
Yes, ma'am.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
If you are not do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in the deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, how do you wish to plead to the charge that on or about January 1 of 2023 in the city of Adrian in the county of Laraway that you did commit the offense of police officer fleeing 3rd degree? Guilty or not guilty?
Guilty, ma'am.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Steen?
No, Your Honor.
And Mr. Dagger Margosian?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be, Mr. Deck?
There was no promises, but he did say I might get probation or a time served. That's about it.
All right, he didn't promise you that, but he said you might.
I might, yeah.
But you understand at the end of the day, it's my decision what your sentence.
Yes, ma'am. Yes, ma'am.
Okay. So is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Deck, on January 1 of 2023, were you in the city of Adrian in the county of Laraway?
Yes, ma'am.
And were you driving a silver Dodge Ram?
Yes, ma'am.
All right, and was it daytime, nighttime, early in the morning, after New Year's Eve? What was it?
It was nighttime.
Okay, so it was dark out, right?
Yes, ma'am.
All right, and at some point, a city of Adrian police officer came up behind your vehicle. Is that correct?
Yes, ma'am.
I missed. Okay, and did he have his lights on?
Yes, ma'am.
And so when he came up behind you and turned on his lights, did you understand that was directing you to pull over?
Yes, ma'am.
Okay, and in fact, you did not pull over. Is that correct?
Yes, ma'am.
and you actually increased the speed of your vehicle where the speed limit was 35 miles per hour or less, and you increased the speed over that speed limit?
Yes, ma'am.
Okay, and that was your intention to get away from the police officer?
Yes, it was.
Okay, but did you crash the vehicle or something? Because they eventually had contact with you, is that correct?
No, ma'am.
Okay. All right, Mr. Sneed, are you satisfied?
Yes, Your Honor, thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, I have.
Mr. Dagger Margosian?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to set this matter for sentencing on April 7th at 8:15 in the morning. And before I go any further, do you wish to address something bond, I believe, Mr. Decker Margosian?
Yes, Your Honor. Your Honor, I'm asking this court to grant a personal recognizance bond to Mr. Deck. The factors are, number one, he has an address that is separate from any alleged victim in this matter. Obviously, the assaultive charges will be dismissed at the time of sentencing. He has a job. He's been in jail for 3 weeks or so. He's obviously taken responsibility today. One hang-up in district court that was not addressed when I was addressing bond is that they were under the impression that he was on bond at the time of January 1st of this year. He wasn't. There was a warrant out, but he wasn't on bond. So I think that had that been addressed, he probably would have been released. But in any event, I just wanted to give that information to the court. But other than that, like I said, he's taking responsibility. While there are no sentencing agreements or COB discussions or anything, just very quickly looking at the Class E grid, he has he has 2 prior misdemeanors, but no felonies, nothing else pending, no weapons were involved, no injury. So I'm anticipating guidelines to be pretty low, and I obviously we'll deal with that at the time of sentencing, but I think it would be appropriate to grant a personal recognizance bond here.
All right, Mr. Sneed, will take any position?
Your Honor, in light of the plea today, we wouldn't have any objection to that, but I would like to have the address placed on record.
All right, so Mr. Deck, I'm going to put you in a breakout room with Mr. Moore here in a minute from the Michigan Department of Corrections. And I want you to give that address to Mr. Moore, and he'll make sure that the court gets it, because we're live on YouTube, so I don't want your private address on YouTube. And then Mr. Deck, when you meet, I will give you a PR bond. There's to be, your bond conditions continue, no contact with the victims on the other 2, victim or victims on the other 2 files. I don't have a police report because I don't get that. Was alcohol involved in this at all?
No, ma'am.
All right.
I don't believe so.
Okay, so a sober bad choice that day, Mr. Deck. All right, so I will set this for sentencing on April 7th at 8:15 in the morning. Mr. Deck, do you wish to be present in person, or do you wish to appear for sentencing via Zoom?
I will be in person.
Okay, so we're gonna put that in person at 8:30 in the morning on April 7th. And Mr. Deck, I'm gonna put you in a breakout room with Mr. Moore. When you meet with him, he's gonna give you instructions on how to proceed going forward, and he will get your new address and provide that to the court. When you do meet with the Michigan Department of Corrections, be truthful about the events that occurred and also your background. He'll prepare a pre-sentence report that will be provided. We'll provide that to Mr. Dagger Margosian. You need to, once you're released from jail, make sure Mr. Dagger Margosian has a valid phone number for you, and he will reach out to you and review the pre-sentence report. We'll see you back on April 7th at 8:15 in the morning in person. So let me open up that breakout room.
Yeah, ma'am.
Yep.
So, okay, ma'am.
So Mr. Docket, Mr. Moore. All right, and all your other bond conditions will continue, so.
Okay.
Open up that room, go ahead and join it. All right, Mr. Degemark goes in. Let's see what else we got. So did Overton, we took care, we did Doc. Mr. Degemark goes in unless
Your Honor, I think the only thing that I have left is
Aaron Carr.
at 11.
All right, oh, and that's at 11?
I mean,
No. Yes.
it's scheduled. I'm happy to do it earlier than that if we can, but whatever the court wants.
All right, do we have, let's see your file. Becky, was she set for sentencing?
It's a sentence. It's a contempt of court sentencing. She should be in jail.
She is, not a violation sentence, just contempt of court.
It was one of those. It was a delayed sentence violation. So, however we want to categorize that.
Okay. Did you get? Well, I have it. Miss Adams, we can let the jail know. We'll take this car. Hold on, Mr. Leisure. We do have some of your people. So this is contempt of arraignment. Contempt of arraignment. So I don't have notice for today in the file. So Miss Adams, I don't know what the note said for her. So Mr. Degemark goes in, she pled to the contempt of court. Sometimes the paperwork just doesn't make it to my file within a week. So she pled to the contempt of court and she failed to appear for a show cause. And did she plead on the underlying show cause as well?
She pled to the alleged violations, which were missing drug tests and not appearing. And then Mr. Coase subsequently talked with her in jail.
All right. So, Miss Adams, will be Mr. Post and Miss Cox. All right. So, Mr. Blazer, I think I have some people. Mr. Blazer, is Mr. Wetzel with you? He usually is, I thought.
Yes, he is, Your Honor.
All right, you ready for him?
Yeah, I'll have to go get him.
Hi, Mr. Malaro.
Hello.
All right, so Mr. Malaro, I have Matthew Martin, Lisa Hannawalt, and Mr. Hill. Mr. Hill is yours, right?
Correct.
Mr. Coast, we're coming in on Aaron Carr.
Okay. 9.5.
Mr. Hill, can you hear me?
Yes, ma'am.
All right, excellent. So this is in the matter of the people of the state of Michigan versus Rodney Lamont Hill. We have two files, file number 22-21189FH and 22-21190FH. I have Salvatore Malaro appearing on behalf of Mr. Hill, and I have Isaac Sneed, Anthony Bayonetto, or I'm sorry, Anthony, like you're the only Italian not named Anthony. I have Alexander Bayonetto appearing on behalf of the people. This is the time set for pre-trial. So, Mr. Malaro, how do you wish to proceed with Mr. Hill today?
Your Honor, I'd ask to adjourn these matters. Mr. Bayonetto had sent me a plea offer, but I was not available yesterday to review it in depth and or to get a hold of Mr. Hill about it. So I'd ask to adjourn this out.
All right, so Mr. Hill, Mr. Malaro is going to want to meet with you. So I can set this out to the 22nd or to March 15th.
Could we do March 15th, Judge?
All right, so Mr. Hill, I'm going to adjourn this out to March 15th at 8:30 in the morning for a pretrial conference. Mr. Malaro, at that time, we'll probably set a trial date if it doesn't get resolved. So Mr. Hill, same number, and just call back in on March 15th at 8:30 in the morning for your next pretrial. And Mr. Malaro, you do the stip in order to adjourn?
Yes, Judge.
All right, thank you, Mr. Hill. You have a good day.
Thank you. You too, ma'am.
I'll call you, Rob.
All right.
You're all set. You can disconnect. All right, I have someone on a Galaxy phone, and looks like I'm looking at a bathroom counter. Anybody there? Hi there. What is your name?
Lisa Butler.
Right. Lisa Butler.
It's on the Ryan Laraway case.
Oh, okay. All right. So I'm going to change your screen name.
Okay.
And I will put you in the waiting room. And then when we get to that file, I'll bring you back in. All right.
Thank you.
You're welcome. I do not have a jail window anymore, but I do have Mr. Wetzel. All right, this is in the matter of the people of the state of Michigan versus Matthew Mark Wetzel, file number 22-20850FH. I have John Glazier appearing on behalf of Mr. Wetzel, and I have Isaac Sneed appearing on behalf of the people. This is the time set for a retrial on this matter. Mr. Glazier, how do you wish to proceed today?
Yeah, there should be amended information in the file. My client's going to plead guilty to count 2 with the understanding that count 1 would be dismissed at the time of sentencing and that there would be a Cobb's plea to, or Killebrew plea, excuse me, to no upfront jail.
Mr. Sneed, is that correct?
That is correct, Your Honor. Also, as part of the plea, I believe there is a financial account that the defendant will be turning over for purposes of restitution.
Your Honor, in that regards, I sent a letter to Mr. Sneed. I think I discussed it with Jackie as well. My client has 3 accounts, and I've sent those accounts to the prosecutor, and in the letter, I refer to them as accounts A, accounts B, and count C. Count A, which I think is about $9,000. We agree 100% that would be applied to restitution. Counts B and C are subject to a divorce judgment, Your Honor. Those are ordered. That is, his ex-wife, is a surviving spouse, and his children are named as beneficiaries on those plans. My client is quite ill, Your Honor, and his kids is highly likely will inherit those within the next couple of years, probably. But we left it with Jackie that we would leave it to the court's discretion on whether you're going to enforce those. Those 2, like I say, are subject to a divorce that's over in Judge Alsager's court. A judgment has already been entered.
What's his ex-wife's first name?
Natasha.
All right. So Ms. Wetzel, who is a teacher at Lincoln, correct?
Yes.
Okay. All right. So I don't, I wasn't aware of that. So I will say that I do know Miss Wetzel. I actually performed a wedding ceremony at Lincoln yesterday for Miss Wetzel. for queuing you. So I do, and my daughter also went to school there. So I feel that I can make a decision that would be unbiased, but I do want to at least place that on the record. And Mr. Glazier, if you want the sentencing, like I could take the plea, and then if you're not comfortable with me making that decision, I could send it to Judge Oldsaver.
Judge, we don't.
I mean, I'm not friends with her. I've never socialized with the Wetzels. I've never
We
seen them
have-
out.
We have no objection to either one of you making that decision.
Okay, okay. So, all right, Mr. Sneed, any objection?
No, none whatsoever. Thank you, Judge.
All right, and it's, he's going to be guilty or no contest?
He's gonna plead guilty, Your Honor.
Okay. All right, so count B and C are in dispute.
Counts what?
Accounts B and C are in dispute.
Yeah, there's a letter, Mr. Sneed, or I can give you a copy of it. I didn't send a copy to the court.
Okay. All right. Well, that's probably a matter of law, so good thing I have a really good judicial attorney that can look that up. All right, so, Mr. Wetzel, can you raise your right hand for me, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, can you hear and understand me, Mr. Wetzel?
Yeah.
Okay, go ahead and put your hand down. And then I'm gonna need you to speak up a little bit. So if you have to move closer or if you just raise your voice, either would be fine. So, Mr. Wetzel, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2 embezzlement, agent or trustee, $1,000 or more, but less than $20,000?
Yes.
All right, do you understand the maximum penalty for that offense could be up to 5 years in prison and or a $10,000 fine or 3 times the amount embezzled, whichever is greater? Do you understand that?
Yes.
All right. Now, are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes.
All right. Other than the Killebrew agreement that was placed on the record, Killebrew to no upfront jail, and the agreement that count A would be applied to restitution, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazier?
That's correct, Your Honor.
Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
And Mr. Wetzel, is that correct as far as you're aware?
Yes.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have a right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, Mr. Wetzel, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right. How do you wish to plead to the charge that on or about March 14th of 2022 in the city of Adjourned in the county of Laraway, that you did commit the offense, embezzlement, agent or trustee, $1,000 or more, but less than $20,000.
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge other than what was placed on the record?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes.
Okay. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
Mr. Steen?
No, Your Honor.
Has your attorney promised you any particular sentence or estimate of what your sentence will be, Mr. Wetzel, other than the no upfront jail? Like, did he make any promises about fines or costs or how long you might be on probation?
Right, that's no.
Okay. All right. So, and is it your own choice to plead guilty?
Yes.
All right, Mr. Glazier, would you like to lead your client through the plea? Factual basis.
Yeah, Mr. Wetzel, you were previously employed by Donna Baker, is that correct?
Yes.
And what business is she in?
Taxes and accounting.
And what was your job there with Donna?
Well, both taxes and accounting.
We didn't hear that, so he's gonna need to speak up.
Both taxes and accounting.
You did tax and accounting work?
Yeah.
Both?
Yeah.
All right. And while you were an employer, did you take some money through your work that belonged to the firm or belonged to Donna Baker?
Yes.
And you didn't have any right to take that money, is that correct?
No.
And it was certainly between 1,000 and 20,000. In fact, it was higher than that, is that correct? Higher than 20,000.
Yes.
Okay. And that all occurred here in Laraway County in the state of Michigan, is that right? That work and that embezzlement?
Yeah.
And that was on or about, it was over a period of time, wasn't it? But it was near March of this year? Or was it?
Yes.
Okay. I don't have any other questions, Your Honor.
All right, Mr. Steen, any further questions?
No, people are satisfied, Judge.
Has the court complied with MCR 6.302 B, C, and D? Mr. Glazier?
Yes, it has, Your Honor.
And Mr. Steen?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of them other than the Kilo Group plea. I'm going to refer this matter to the probation department for a pre-sentence investigation. So, Mr. Wetzel, I'm going to place you in a breakout room here in a moment with Mr. Moore. Mr. Moore is going to give you instructions on how to proceed as we move forward. When you meet with the probation department, be truthful with them about your background, the events that occurred. They'll prepare a report. We will provide that report to Mr. Glazier in advance of sentencing, and he's going to review that with you. And then we'll be back on April 7th at 8:15 in the morning for sentencing. Are you available that day, Mr. Glazier?
I believe so, Your Honor.
All right, so April 7 at 8:15 for sentencing. And I'm going to pop you two in a breakout room with Mr. Moore.
Your Honor, did you want me to send you that letter with the 3 accounts on it?
I think if it's not something you and Mr. Sneed can agree to, I'll probably need to set it for a pretrial to talk to you guys about it.
Okay, did you want a copy of it or not? It's the letter I sent to Mr. Sneed.
You can send it to Miss McGrain if you want.
To who?
Sierra McGrain, my judicial attorney.
Okay,
Yep. All right. So, Mr. Moore and Mr. Glazier, go ahead and join that breakout. Ms. Carr, all right, let me grab your files.
Judge, may I speak with Ms. Carr before we call the case?
Sure. And Mr. Coast, are there any updates on Ms. Carr?
Judge, I submitted that letter for your review of my recommendation.
You did, but I don't know where it is.
Judge, I could get you a copy. I'll be right down.
I remember you did. I don't know what I did with it. Did you get a copy of it, Mr. Degemer-Gozian?
I did, and I've reviewed it, Judge.
I'm guessing it's on my stack on my desk. So, okay. So Ms. Carr, I'm going to put you for some change of training. You don't look like Mr. Docket. So, what's that? All right. So I'm going to assign you both to the breakout room. Okay, go ahead and join that breakout room. You're already back, Mr. Glazier?
yeah, and Mr. Moore was short. I asked him if he was part of MAGA with that big United States flag behind him. Yeah,
It's just cut. It's God, family, and country. It's all that is.
Yeah, it's not election season. We can't do anything political during election season, but
It's not political.
All right, my client's heading up there right now, Tom.
All right, thanks.
Yeah. We'll see you later.
Sorry about that.
Yep.
I know I saw it.
Oh, you're good.
I apologize. So, Mr. Glazier, hold on one second. Let's see who else you got.
I have Diethos.
I got Gage.
Gage and Diethos.
What's the other one?
Diethos.
Oh yeah, Diethos. Yep. He's in jail too.
Yeah, they're both in jail.
So I'm on the waiting list for a room at the jail. All right, I got Sam though. So Keelan Anderson, he's in jail. All right, I got Matthew Martin, Mr. Malaro.
Yes, Judge.
Hello, can you hear me?
Thank you. All right, so this is in the matter of the people of the state of Michigan versus Matthew Dean Martin, file number 21-20466FH. This is the date and time set for a final pretrial conference in this matter. We do have a trial scheduled for one day on April 12th of 23 at 10:30 in the morning. Let's see, the plea is plead to an attempted conspiracy, which is a 5-year. Dismiss count 1 and count 2, which are 10-year felonies, second offense. So those 10-year felonies would become 15-year felonies. All right, so Mr. Malaro, where do we stand?
So Judge, I did get a phone, Mr. Sneed and I spoke yesterday briefly. I'm going to either meet with him later this week and or next week to go into this case a little more in depth.
Nobody else.
Mr. Martin, we can hear all that. So hold
There's
on.
also an anticipate, if we can't find this, get this resolved, there's also an anticipated motion to file on the case, so. That's where we're at,
Well-
otherwise we'll leave the trial as it is.
Yep, yeah, plenty of time to do that before the trial. All right, so we will continue this matter to trial on April 12th of 2023. In the event that a plea agreement is reached that Mr. Martin would like to consider, I would ask that you bring them in prior to the day of trial. Just that helps with my jury, so.
Good. Judge, could I have a brief breakout with Mr. Martin? Just real quick.
All right, Mr. Martin, you need to also make sure you stay in contact with Mr. Millar, all right?
Thank you.
Yes. All right, go ahead and join that breakout room. Mr. Martin, so you came back. So I need you to actually, on your screen, there should be something in the bottom that says breakout room or join breakout room.
No, it just says John Glazer.
No. Down at that little bar at the bottom with all the icons.
Okay, where it says breakout room.
Yeah, go ahead and join that breakout room. Who's Marcia? No, it's popping you right back in. So hold on a minute.
Okay.
For some reason, this happens on some people's devices. It pops them back in. So give me just a minute. I have someone who logged on named Marcia. What is your name, ma'am? Oh,
Marcia Crater, I'm here, I'm representing Laraway. I apologize. I thought they had corrected. I apologize.
oh, that's okay. Do you know how to change it?
Yeah, I do. I apologize.
Okay.
If I could interject here, I'm sorry to interrupt, but if I can save Ms. Crater some time. We're going to be submitting a motion for Nolle Prosequi regarding Mr. Laraway today based upon some conditions that have been satisfied. So I just want to make that aware.
So we don't need to hear the motion because you're dismissing the charges?
That's correct, yeah.
All right. Do you wanna just call Mr. Laraway?
I'm sorry.
Did you hear what Mr. Sneed said?
Yeah, I would like to, yes. I did, and I don't know if because I'm on my cell, I don't see Mr. Laraway if he's present or.
So I haven't let him in yet, so I was asking whether you wanted me to let him in, or do you want to just call him?
No,
Okay.
please I would like to hear what Mr. Sneed.
And I think there's some witnesses here. Hold on.
Just an
So
observer.
All right, hold on, Mr. Milaro, Mr. Martin can't join the breakout room. He was trying and it just pops him right back out.
Yeah, Judge, I told him to call me and I gave him my number.
Okay.
I told him to get off of Zoom and then to call me.
Okay. All right, Mr. Martin, you have a good day.
All right, thank you too.
All right. All right, so where's that? In the matter of the people of the state of Michigan versus Ryan Paul Laraway, file number 21-20438FH. I have Isaac Sneed appearing on behalf of the people and Marcia Crater appearing on behalf of the defendant, P 71163. Mr. Sneed, stated on the record that this file is being Nolle crossed.
That's correct, yeah.
There's been compliance with something, so, anything else, counsel?
No, thank you.
All right. Ross,
No, you-
thank
Thank you.
All right, thank you. Okay. All right. Let's see. Mr. Laraway, you're all set.
Thank you.
Thank you. All right, I have Lisa Hannawalt, who is Miss Butler. I think you were here just to listen in on that case, right?
Correct. I'm trying to get out of it now.
Okay, I'll help you.
Thank you.
Not a problem. All right, so. Lisa Hannawalt. All right, Ms. Hannawalt, all right, this is in the matter of the people of the state of Michigan versus Lisa Marie Hannawalt. We have two files, 23-21232FH and 22-21152FH. Looks like I still need prints on one of the files through Adrian Police Department. The order has been sent over there. So Ms. Hannawalt, we do need you to get your fingerprints done on that. So it's first pre-trial on one file, second or third on the other file. So Mr. Malaro, how do you represent Ms. Hannawalt and Isaac Sneed on behalf of the people? So Mr. Malaro, how do you wish to proceed?
Judge, I'm going to ask to adjourn both files, and the reason is these are Miss Mears cases. On the 152FH file, I need to meet with Miss Meir and bring some information to her attention that may probably resolve that one. And then the other file, the 232FH file, I also need to talk to Miss Meir and see what, if anything, can be done on that.
All right, so Mr. Glazier, tell Mr. Murphy he's being very loud back there. All right, I can hear his voice in the background. All right, so we will adjourn this for another pre-trial on April 5th at 8:30 in the morning. And Mr. Malari, you did the stipend order to adjourn both of these, correct?
Yes, I will, Judge. I'm sorry, Judge, what was the date again?
April 5th at 8:30.
Yes, thank you. Please
All right,
make an appointment to come see me next week, okay? Just have a thumb up if you're okay with that. Or don't. Okay. All
Okay,
right.
thank you. All right, I have one jail window, so I'm gonna have to close it. Mr. Day. He's already coming back. All right. So, Mr. Dagger-Margosian, let's get Miss Carr back. And then Miss Adams from the jail, if I could have Mr. Dietos next.
Okay.
And then Cody Gage. Gotcha. All right, so I'm back on the record with Miss Carr. All right, so I have received again another copy of the letter from Mr. Post that I received previously. This is a delayed sentence, and she was on probation with our pretrial services coordinator, Mr. Coast. She did plead to the contempt of courts. So, Mr. Dagger-Margosian, have you had an opportunity to speak with your client?
Yes, Your Honor.
All right, is there anything you'd like to say on behalf of her before I sentence her on the contempt of courts?
Your Honor, I know that Ms. Carr plans on addressing the court in her allocution, but the only few things that I'll address is that I know that it would be nice for us to have drug users stop using drugs, but as this court knows, as you know, running drug court, it's a cyclical thing, and it's not as easy as somebody on the outside wants to make it seem. What I will say is that Ms. Carr, while she has admitted to the drug use, it was not heroin, and I know it was just cocaine, and I know that's a small distinction, but I I and she view it as somewhat of a victory to be able to at least take one step away from intravenous administration of heroin and drugs. I think that's an important thing to note. Obviously, sentencing is in your hands alone. She's been in jail for about 10 days. She looks better than she was last time, and she's going to look better, moving forward. If this court finds an inpatient bed, so be it. If not, she'll do a X amount of days in jail. And I've reminded her, and I'm sure this court will remind her, and I know that Mr. Coates will remind her, she's got to find structure. She's got to find foundation, because otherwise it's just going to happen again. And she knows it, but sometimes you got to take a step back to move 2 steps forward. So I'm hoping that she does what she needs to do and gets her mind right. The one thing I will state is that there's mention that if she violates again, the initial felonies would be reinstated. I don't think that's a legal option, but I don't need to address that right now. So,
well, I mean, it's just that the delayed sentence could be removed and she would remove the sentencing. So,
correct. So, other than that, I truly wish Ms. Carr the best of things. She wants to move forward herself. A person isn't just making these decisions just to flaunt it in front of a court. I mean, using drugs is a serious disease and condition, and it takes support. So I know the court will provide that support for her.
All right, Ms. Carr, anything you'd like to say on your own behalf?
Yeah, I actually wrote a letter, so hopefully I can read it without crying, if you don't mind.
Oh, of course, go ahead.
Okay. Here we are again. I'm tired of this fight within myself that I understand only I can do something about. I'm tired of living this life in and out of trap houses, no running water, and to even go to the bathroom or brush my teeth. Being so hungry, I can't sleep. Waking up from being Narcaned with no recollection of what happened. Being thankful, I guess, that people that I was around didn't want murder charges on their record enough to want to save my life. I'd be silly to say and actually believe that it was because they cared for Aaron. 1 minute relaxing, hanging out with people I used with, to 20 SWAT officers breaking down the door, screaming and yelling with their guns all drawn, pointing at me. It's truly like the movies, and I pray God allows me to think more clearly, make better choices, and really give another effort to never go through any of this stuff again. I can only make these chances with good support people in my life, and I need help, serious help, and I've let my addiction take everything I love, down to a few bags and 1 pair of shoes. And if you know me, that's crazy. I've never been this low. I miss my family. I miss them so bad it physically hurts my heart. My mom has cancer. I need to make her smile and make her proud. I know my dad is so stressed. I don't even have to see him to know he's tired and frustrated and deserves to enjoy this time with my mom. I hear he only sleeps good when I'm locked up. How devastating to hear. My daughter is almost 20 years old, doing an apprenticeship at a salon, as well as working second shift, helping her brothers, running her brothers around, going with my mom to doctor's appointments, and dealing with my dad who can't help, but give her a hard time because he cares and loves and is tired. As well as having my mom addicted and absent. It's simply amazing. My boys, my 3 boys, I only know anything about them because of what people tell me. I'm not there, and I should be ashamed of myself for that. And believe me, I am, until I choose to numb the pain and forget, or try to anyways, about anything and everything that I truly loved and cared about. I know that I've tried to use this as the easy way out, but it's the most hurtful and the most painful for everyone that I love. How selfish. Almost 40 years old, living in the streets like I'm 20, with no care in the world. It's sickening and embarrassing, and I'm tired. I've escaped death more times than any person could probably imagine, from over 30 overdoses, and that's no exaggeration, and the worst car accident that has changed my life and soul forever. God keeps throwing me safety nets, and I need to take this seriously or not, but wasting everyone's time and energy if I'm not going to be vigilant and try hard to get clean. I've not had a drink since 2014. I know I can do this, and with the right people and the tools. Please, I'm begging and pleading for yet another opportunity to prove that I can, not only to make my mom and dad and kids proud, but to show you when you think you have nothing left in life but one person to call on, it's the time to call on that one person, and that's me, to do something about it. I know jail is the perfect place to get clean, and if it wasn't for this time I did this summer, I would probably most definitely be dead. I've quit using IV drugs since June 23rd, but I've substituted it with other substance. I'm thankful for the clean time with no needle. Actually a little proud of it too, but I'm not finished yet. I have more work to do, and it will begin when I get out of here. People, places, and things, and that's what has to change. I know in time I can have an army behind me again, but they want and need me to want it more than that. Taking away my true sentence would change my life forever and allow me to prove to you, please allow me to prove to you and to myself that you made a solid decision by giving me another chance.
So, Mr. Moore, is Miss Teskey working today? I think under the statute, she's eligible for drug court. I mean, my concern, she's shaking her head, but, I don't know. I mean, we can try to rehab, but, we can get you sent to a rehab. But you understand if you don't go and you don't complete it in aftercare, you're going to lose your delayed sentence. Do you understand that?
I do. Mm-hmm.
And then you're going to have a choice. I think you didn't want to do drug court before. Is that right?
No, it's not that I didn't want to. I just haven't heard I'll be honest, I haven't heard very good things about it and a very good success rate. I mean, honestly, that's the truth of it.
Okay. So do you understand if I sentence you and I allow you to be released to an inpatient program, you have to go there and you have to stay in the program?
I absolutely understand, yes.
And some of them have transitional housing afterwards so that you have a place to live and you're not, because
which is huge for me, because that's something that I've been stressing about. So if I'm able to stay out of the county, like I didn't know how that works. So if I'm able to do that, then that would be huge for me, for sure.
So would Dawn Farms be available during Mr. Coast?
Yes, Judge, I'll get her evaluated through CMH, but yeah, Dawn Farms is typically an option.
Okay, all right. Anything else?
How long does it usually take to get into Dawn Farms? Do you have any idea?
It could be anywhere from 2 days to a couple weeks, depending on when they have a bed open.
Right, okay. And who sets that up? Darren does?
Mr.
Yeah, what I'll be doing is I'll send you over a release form to sign for CMH. Then CMH will actually interview you.
Okay.
And then we can proceed from there.
Okay.
Anything else, Mr. Sneed or Mr. Dagger-Margosian?
No, thank you.
Thank you.
Okay. So Ms. Carr, I mean, it's clear that you know what you're doing is going to kill you. And it's clear that you want to get help, but I get it, it's hard. I mean, I see people struggling with it all the time. So it's going to be the sentencing court that you will serve 60 days in Laraway County Jail. If a bed becomes available, you can be transported to that program. It'd be better if we could get you into something that has some kind of transitional living afterwards, just to keep you out of our county. Because, obviously, not that you're, it's just that all your bad influences are here.
Right.
You've already been in for about a week or so. So Mr. Coast, as soon as the bed's available, I have no problem for being transferred.
I'm satisfied with that too, Judge.
Okay. All right. And then understand, go to the program, work the program, do what you need to do. You can lose this delayed sentence, which means that, we'll come back for the original sentencing, all right?
Okay, thank you very much.
All right, Ms. Carr, I wish you the best of luck, all right?
Thank you, thank you.
Thank you, Judge.
Thank you, Mr. Coast.
Judge,
yes.
Are we continuing a bond on her original charge, and was there a jail sentence on this?
I thought that the sentence was on both files. Because I had a contempt of court on both files.
Right, but I think when there's a bench warrant, it revokes the bond on the underlying charges.
Okay, so she'll get credit for time served. And then I'll release her on a PR bond on the underlying files.
Okay.
with the condition that she go to Dawn Farms. Is that good?
Sounds good, thank you.
Okay.
Thank you.
All right, thank you, Ms. Carr. Okay, so just waiting on the bill. What do you have? Miss Adams, could you call Miss Idding's office and let her know that I misspoke about Mills?
I'm sorry, Miss, let her know what, Judge?
So Miss Iddings contacted the court because she heard that Mills was on at 8:30. And it's a PPO case, but I don't think Miss Iddings is on it, but she might be on the divorce case.
Judge, I spoke with her this morning.
So what am I doing on the PPO file?
My understanding is that it's a show cause and against not Miss Idding's client, so I'm not sure that she would be present.
Okay, and the respondent in that file was Mr. McFarland's client, David McFarland's client. So I have an order to show cause, but I have no proof of service.
I don't have one in my file either, Judge.
Okay, so in the matter of Brenda Ann Mills versus Ashton James Mills, file number 22-49732 PP. There was a show cause set today. I do not have a proof of service. So Mr. Sneed, I guess we'll try again, right?
Thank you, Judge.
All right, thank you. Miss Adams, you want to come get some files?
Excuse me, Your Honor. I will. I'll be right back.
Okay.
Can I get Daniel to have stuff?
All right, sir, what is your name, please?
First name is Chris, last name is Dietos.
Right, hold on, Mr. Ethos. This is Mr. Glazier. So, and I'm waiting, oh, I got Miss Bice. Forgot you were still there, Miss Bice.
I gotta turn up my volume. I can't hear anything.
Can you hear me now? Miss Weiss, can you hear us now?
Yes, sorry about that.
Not a problem. So this is in the matter of the people of the state of Michigan versus Christopher Nicholas Dietos, file number 22-21180FC. I have John Glazier appearing on behalf of the defendant, and I have Jacqueline Weiss appearing on behalf of the people. This is the time set for a first pretrial conference in this matter. Mr. Glazier, how do you wish to proceed? You're muted, Mr. Glazier.
Sorry about that. I just got last week a criminal responsibility ruling by the Health and Human Services. I need to have an independent done.
Well, hold on a second. Hold on. Did we place the criminal responsibility on the record? And
that's not one you would put on the record. The competency had been put on the record well before. We just didn't have the criminal responsibility.
Okay. So you have that now.
Yes.
So you're going to have an independent done.
I'm going to have an independent done for criminal responsibility as well as ability, his ability to assist me at trial. We have a person we use. I don't know if I need an order, but I'll have an order prepared if Your Honor doesn't mind. And I'll put in the name of the person we use.
Do you have a time?
I'm here.
Miss Weiss, what did you say?
I just asked him if he had a time frame, like how long. I have no objection, obviously, to him getting an independent. I was just wondering if we have a time frame, looking out how far your guys doing it.
Independent are usually shorter than the state ones, which can take a year. So.
I've got to get a hold of the person. So I don't know. Maybe.
So what I suggest would be a May 3rd pre-trial, and if you need to adjourn it, you guys can just stick to adjourn it.
Okay.
Okay.
And Mr. Dietos, I got your letter. I will set up a Zoom conference to speak with you next week.
Can I speak to you in a breakout room real quick? I have something I'd like to speak to you about.
Yeah, I don't have a problem. If you can't, Judge, that's fine. I'm going to talk to you next week, Mr. Dietos.
But can I give you my mother's phone number? She'd like to speak to you.
Yeah.
So, hold on, everybody, hold on. So we are live on YouTube. So, Mr. Dietos, I don't want any phone numbers being placed on the record. So
all right.
you just tell your mother to call Mr. Glazier. All right.
She doesn't have his number. That's why I had to give her.
You do on all your paperwork has the public defender's office.
Okay.
Or if she can't find it, have her call the courthouse and get the public defender number. All right.
All right.
Okay. So all right. So we will set this out to May 3rd at 8:30 in the morning, and then Mr. Glazier, you can do the stipend order to adjourn.
Yeah, I'll do that too, Your Honor.
Okay, and then I'll sign the order upon presentation.
May 3rd at what time?
8:30. All right, you're all set, Mr. Dietos. You have a good day.
Thank you.
Thank you.
Well, maybe you can see my attorney from my freeway.
Okay, so I guess from the jail now, Mr. Glazier, I need Cody Getch, so hopefully we'll get him. And then I just go back to Sam, but I think Sam's kind of bopped over next door.
You fought before, you fought for me before a while ago. We did great.
Oh, Matthew Martin, did we, Sue?
I believe we did. They already have a trial date for 4/12 and they're trying to resolve it.
All right. All right. Hey, it's more than a week. I really like that. I give it to them. Thank you.
Thank you.
Yeah.
Okay, I got it.
Oh, that's cool.
Isn't that funny?
Yeah.
Brad, you got anybody in health?
Oh, it's up there.
That's fair. Then he has to do a jury trial. You'll have to tell about money. Remember to get it for
All
her.
right.
She won't know that
It's
you.
right there.
It's right.
What's that, a female?
Hang on.
Yeah. Right now, yeah.
Yeah.
Judge Olsaver's missing your smiling face, he said.
I still got one more to do
Oh,
here.
all right, well, I told him I'd tell you.
right.
Apparently he thought you ran away or something.
Becky, can you call the jail and tell them we need Mr. Getch? And, please. Cause I think, yeah, I do have one. You have Getch, and that's the last one you have, Mr. Glazier, so.
Yeah, that's
Sorry.
right.
Judge, did you already do Anderson?
No. But I don't want Anderson, that's Sam Malaros. I wanted Cody Getch for Mr. Glazier, so he could go down to Judge Olsen.
Right, I did ask for this.
Hi, what is your name, please, from the jail?
That's Cody Gage.
Gage, okay. Let me rename you. All right, so got your file. This is in the matter of the people of the state of Michigan versus Cody Wayne Gage, file number 23-21257 FH. I have John Glazier appearing on behalf of Mr. Gage, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for arraignment in this matter. Mr. Glazier, do you waive the reading of the felony information?
Yes, Your Honor, we waive the reading of the felony information. And let me talk to my client to see if I need to set this for a pretrial, Your Honor.
Okay, Mr. Gage, I'm going to open up the breakout room for you and Mr. Glazier. Go ahead and join that breakout.
All right.
Mr. Malaro, I think I have
Yes, Judge.
let me see here.
Caleb Anderson.
Yeah,
Can I talk to
Maybe it's a
Mr. Sneed on that in a breakout?
all right. So, Mr. Malaro, and I'm gonna close it as soon as I get Mr. Glazer back. All right, and Mr. Steen, go ahead and join that breakout room. All right, so let me close these breakout rooms. What's up? All right, so we are back on the record with Mr. Gage. Let me start the video. All right, so Mr. Glazer, this is a date and time set for arraignment. Do you waive the reading of the felony information?
I do, Your Honor. My client's gonna enter a plea of guilty to count 2, aggravated stalking, and count 4, intentional dissemination of sexually explicit visual material. With the understanding that count 1 and 3 would be dismissed at the time of sentencing. Ms. Mears also indicated that she would not issue any other warrants for him for, she's received some complaints. So she said up through February 6th, that was the day we waived the exam. She said she would review those, but she isn't going to issue any other warrants for stalking or harassing behavior or anything like that.
All right, Mr. Sneed. Is that
It's accurate.
Okay. All right, so it's Gage, right?
Yes, ma'am.
All right, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, and state your full name for the record again and put your hand down.
Cody Wingate.
All right, now, Mr. Gage, you've heard your attorney's statement. Is it your intention to plead guilty to count 2, aggravated stalking, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine and 5 years probation, as well as count 4, intentional dissemination of sexually explicit visual material, which carries a maximum penalty of up to 93 days in jail and a $500 fine. So one's a felony, one's a misdemeanor. So is it your intention to plead guilty to both of those counts?
Yes, ma'am.
All right, are you satisfied with Mr. Glazer as your attorney and the advice that he's given you?
Yes, ma'am.
All right, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazer?
That's correct, Your Honor.
And Mr. Steen?
Yes, Your Honor.
All right, and as far as you're aware, Mr. Gage, is that correct?
Yes.
All right. If a guilty plea is accepted, there will be no trial. This means that you're going to be given up rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
All right. If you're not a citizen of the United States of America, I'm so sorry. Oh. A conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So do you have any questions about the rights that I've given to you?
No, ma'am.
All right. How do you wish to plead to the charge that on or about April 4th of 2022 in the city of Adrian in the county of Laraway that you did commit the offense of stalking aggravated? Guilty or not guilty?
Guilty, ma'am.
And the offense of intentional dissemination of sexually explicit visual material? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea, I'm sorry, I've been talking so much, it makes me yawn all the time, that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
Mr. Steen?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be, Mr. Gage?
I don't think so.
Okay. So you understand at the day of sentencing, your sentence will be up to me, right?
Yes, ma'am.
Okay. Is it your own choice to plead guilty to these two counts?
Yes, ma'am.
All right. So Mr. Gage, on April 4th of 2022, did you engage in a willful course of conduct involving repeated or continuous harassment? And I don't use the full name, I use the initials under the new statute. So of an individual with the initials of KO.
Yes, ma'am.
Okay, was there a PPO in place, Mr. Glazier or Mr. Sneed?
I can't remember, Your Honor. Did you have a PPO at the time you guys were?
We had a no contact order.
A no contact order? Okay.
Okay, so there was a no contact order in place. And you were not to have any contact with this individual, but did you continue to have contact with her?
Yes, ma'am.
Were you sending her messages or posting messages?
Yes, ma'am.
All right, and would you agree that a reasonable person would maybe feel terrorized or frightened or intimidated or threatened or harassed by that conduct?
Yes, ma'am.
Okay. And it was a violation of a pretrial release order and a no contact order. So Mr. Sneed, are you satisfied?
I am, Judge. Thank you.
Okay, so then on that same date and time with that same individual, did you disseminate or publish to the public some sexually explicit visual material that that individual was in?
Yes, ma'am.
Okay, and you did not have her permission to do that?
No, ma'am.
And when you did it, it was to threaten, coerce, or intimidate her?
Yes, ma'am.
Are you satisfied with that one, Mr. Steen?
Yes, Judge. Thank you.
Okay, has court complied with MCR 6.302 B, C, and D? Mr. Glazier?
Yes, it has, Your Honor.
Mr. Sneed?
Yes, Your Honor.
All right, I accept a plea that has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to set this matter for sentencing on April 7 at 8:15 in the morning. Mr. Glazier, is there anything else we were addressing today?
No, I didn't need anything else I had to address today.
All right, so Mr. Gage, obviously you're in custody, so you have a choice. You always have the right to be present in court in person. And you know, you'll be brought over super early, you'll sit in a lockup room, you know, for an hour and a half, whatever it might be, or you can Zoom like you did today. It's a little bit more efficient, but it's up to you. So do you want to Zoom in for sentencing or be here in person?
Zoom.
Okay. Is that all right with you, Mr. Glazier?
Yes, it is, Your Honor.
All right, so Mr. Gage, I am going to put you in the breakout room with Thomas Moore. Mr. Moore is from the Michigan Department of Corrections. Or actually, I don't need to, Mr. Moore, right? Okay. So, Mr. Gage, someone from the Michigan Department of Corrections is going to come over and meet with you. They'll give you a packet to fill out the packet, be truthful with them about your background and the events that occurred. They're going to prepare a pre-sentence report. We'll get that report. We'll provide a copy to Mr. Glazier. Mr. Glazier will review that report with you in advance of sentencing, and then we'll be back on April 7th at 8:15 for sentencing. All right?
Okay.
Your bond's continued. Thank you, Mr. Gage.
Is there any way I can talk to Mr. Glazier real quick?
Mr. Glazier has to get to the next court.
Okay.
Now, was that sentencing date the 7th or the 17th?
7th, April 7th at 8:15.
All
All right, Mr. Gage, we'll see you back on that day, all right?
All right.
All right, thank you, Your Honor. Thank you, Mr. Gates.
Thank you. And then we'll need Mr. Anderson next. Thank you, Mr. Glazier. You have a good day. Okay, so I think all I have left is Anderson. And files on 2 pages. So he's got a pre-trial on page 4, and then some arraignments on 1 and 2. And then it's not yet 11:30.
Zoom is, or do you think that
I can't hear you.
Do you think that 11:30 is Zoom with Stimson?
I don't know. If you doesn't say it, so I think he might have said he was over here for something else. So it might be in person now, but they'll be coming in a minute.
I'm gonna tell you, I can't hear you very well. You're so at the very end of your sentences, can't even drop them, so. I try to watch it, but if Mindy's here, if she's sitting here, she won't be able to hear either, so.
I know. Mindy and I have worked together many times, so
Yeah.
we'll figure it out.
But I'll ask you to think, yeah.
Right.
I need you to speak up to it.
Yeah. Yeah, she'll probably Zoom from your office just the way too, so
Yeah.
we'll work it out. Sure. Actually, you might as well you can leave it open. Stimson's just logged in.
What's that?
Stimson zoomed in if you wanna.
Okay. Or unless you're ready to go, I can wait.
It's not 11:30 yet. Just waiting for the jail.
All right. We have Sands too, Sands or Sands.
No, I just got one more Sam, the jail.
The
We have
pickup
two. We've got Anderson and Symes.
Yeah, signs will be Zoom.
Okay.
Mr. Stimson, we're still finishing up the criminal docket, so it'll be a few minutes, all right?
That's fine, Your Honor. I do have a video for our hearing. I'm not sure if it's easier to share my screen for that or how you want to do that.
Just share screen.
Okay.
Right, I'm gonna switch over and leave it to Becky, and I'll be right back. Just trying to get the jail. Gonna go in my office too, so it's gone.
Okay, still open it up though, right?
Yeah, leave it open.
Are we done then, or?
No, but I mean, we're done in here.
Yeah.
Got it.
Yeah. You know, the one we're gonna take right now. All right, I got one more card on there. Where you had it? One for that.
Maybe I got a different jail room. All right, Mr. Anderson, can you hear me? I have a gentleman from the jail. Can you hear me?
Yes,
Okay, what is your name, sir?
David Signs.
Oh, Mr. Signs.
Yes.
Well, it's not. who I was looking
That's a
for.
pickup, Judge.
Yeah, I know. I was trying to get your client, so. All right, so this is in the matter of, I don't have my court reporter yet. Okay, there she is. All right, so this is in the matter of the people of the state of Michigan versus David Royal Signs. Multiple files 22-20805 FH, 22-20804 FH, 22-20803 FH, and 22-20802 FH. Mr. Signs, we are here for a request and warrant for probation violation on each of your files. It is alleged that you have violated the terms of your probation in that on February 4th of 2023, it's alleged you were in possession of a methamphetamine pipe and admitted to using methamphetamine on the same date, discovered at the Share the Warrant homeless shelter. So, Mr. Signs, do you understand that's the allegation against you?
Yes, ma'am. Yes, Your Honor.
All right, so do you understand if you plead guilty or found guilty to this violation of probation on file number 22-20805 FH, you could be facing up to 4 years in prison. On file number 22-20804, you could be facing up to 4 years in prison. On 22-20803 FH, you could be facing up to 4 years in prison. And then on file number 22-0802 FH, you could be also facing up to 5 years in prison. So do you understand that?
Yes, I do.
Now, you do have a right to have an attorney represent you here today and in all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you on this?
Yes.
Okay, so I'm going to put you in the waiting room for a minute and we're going to get a court-appointed attorney and then I'll be back right with you, all right?
Yeah.
Oh, Sam, you're doing the pickups?
Yes, Judge.
I'm sorry. All right, are you Mr. Anderson?
Yes, ma'am.
All right, so hold on, let me change your screen name.
All
right. It's one of those mornings. All right. Put that over here. Okay, so we have multiple files with Mr. Anderson today. And some of them are arraignments. So the matter of the people of the state of Michigan versus Caleb Michael John Anderson on file number 2023-21247FH. We are here today for an arraignment. And then we have set for pretrial today, get back there, file number 22-21106FH and 22-21127FH. I have Salvatore Malaro appearing on behalf of Mr. Anderson, and I have Isaac Sneed appearing on behalf of the people. So, Mr. Malaro, with regard to the arraignment file, do you waive the reading of the felony information?
Yes, Judge, at this time would acknowledge receipt of the information as to counts 1 and 2. Waive their reading in open court, waive any defects of the time and place of service. Mr. Anderson would stand mute and ask that the court enter a not guilty plea. And then ask to be heard on setting future court dates.
Okay, so then I will enter a plea of not guilty on behalf of Mr. Anderson on file number 23-21247FH. We'll continue his not guilty plea on the 2 files set for pretrial. And Mr. Malaro, how far out would you like a pretrial?
Actually, Judge, if we could just do a week. The reason I asked this, and I'd ask to adjourn the other matters a week. We almost had a plea agreement in place for today. There's one in our file that came in on Monday, but I was not available yesterday to go through it with Mr. Anderson. I think if I could get over there this week or next week, I could nail this down, and then I think we could have it resolved.
Miss Adams, do we have any pretrials for March 1 available? Oh, I'm gone. All right. Will next Wednesday be enough time?
Yeah, it's fine, Judge. It doesn't look like Rhonda has much in the way of pickups tomorrow, so at least at this point.
Well, you never know. We don't have the jail list yet. So,
Right.
All right. So, Mr. Anderson, I'll enter a plea of not guilty on that one file, and then I will set them all for pretrial on February 22nd at 8:30 in the morning. So, Mr. Malaro, you do the stip and order for the 2 pretrial files, but Ms. Adams will do the notice on the arraignment file. All right.
But yesterday I had an unavoidable issue that I wasn't available to take care of this ahead of time.
That's okay. All right, that's fine. So we'll see you back on February 22nd. Thank you, Mr. Anderson.
All right, thank
I'll
you.
be over, Caleb. I'll probably be over tomorrow to go over this stuff with you. Okay.
All right,
Okay.
sounds good. Have a good day.
Yep.
You too. All right, so let's back up to Mr. Sains. Get rid of this one. And let me
Excuse me, Judge. You don't need a prosecutor for Mr. Sains, do you? Okay. Have a good
Alright.
morning.
I think that concludes our docket. Thank you, Mr. Sneed.
Good morning, Sam.
All right,
You
so, sir, Mr. Malaro is here, and I'm gonna open up a breakout room and put you and Mr. Malaro into that breakout room and give you a chance to speak. And so there you go. Go ahead and join that breakout room.
Thank you, Judge.
You're welcome. All right, I'm bringing him back, Mr. Malaro, so give us just a moment. Oh. All right, so we're back on the record with Mr. Sines. Mr. Malaro, have you had an opportunity to speak with him?
I have, Your Honor.
And is he eligible for court-appointed counsel?
Yeah, I'm sure he is.
Okay, and how do you wish to proceed with Mr. Sines?
Your Honor, as to all the allegations, we're gonna stay in mute, ask the court to enter a not guilty on all the files. I would ask the court to adjourn this over 1 week for Miss Underwood. This was her case from the beginning. It looks like she put a lot of time in this. She knows Mr. Sane's situation far better than I do, and I don't feel comfortable advising him to file any admissions or make any admissions at this point.
Does
But I
he
think in a
possibly
week-
have new charges?
Yeah, looking at the allegations, he might, so I don't want to jam him up like.
Okay. Pronounce your name again, sir.
Malaro.
Mr. Sines, pronounce your last name.
Oh, I'm sorry, Judge. I thought you meant me. Sorry.
Pronounce your name, sir, because I want to always say Saines or Signs. Signs?
Signs.
Okay, let me write that down. All right, so Miss Adams, when can I set this over to next week?
Is it a trial, Judge?
No,
Probably
I would not. No, not a
the
trial.
arraignment.
Okay.
Mr. Mallory, you literally have the easiest Italian name in the world to spell and pronounce.
You would think.
I mean, everything's booked. You've got like 20.
Thursday or Friday?
Yeah, it's booked. Unless we do like 3:30 on Thursday, the 23rd.
All right, we'll set this for February 23rd at 3:30.
That'd be great, Judge.
Hold on one second. Let me look at something. Hold on one second, Mr. Sines.
Sam, I owe you lunch for that comment. That was priceless.
I thought the judge was talking to me, man. I made it. I'm sorry.
20 years you've been working in the courthouse and we've known you.
Yeah, I've been called worse.
No, she said.
All right, Mr. Malaro, I'm gonna set this for 2/21 at 11:30.
2/21.
At 11:30. So it's sooner, February 21st at 11:30. All right, and that'll be via Zoom. So Mr. Sines, that'll get you back a little bit quicker with Miss Underwood. All right.
All right.
All right. Thank you,
Judge.
Mr. Sines, and thank you, Mr. Malaro.